The Makhanda High Court has given petroleum giant Shell the green light to conduct seismic survey off the wild coast after dismissing an urgent interdict application by lawyers and activists on Friday morning. Shell seeks to gather information about geological structures on the seabed. However, activists and lawyers from Border Deep Sea Angling Association, the Key Mouth Ski Boat Club, human rights law agencies, natural justice and environmental movement, Greenpeace, sought out an urgent interdict to stop Shell. The application was dismissed with cost. For more on this and the steps going forward, we are joined by lead lawyer on the case against Shell, Rick Stone. Rick, good morning. Are you feeling a little defeated after that judgment by the Makhanda High Court on Friday?
How's it, Hugo? Yeah, slightly defeated today, but undeterred nonetheless.
So there is a second interdict, or certainly a number of secondary interdicts that have already been put across. Talk to us about those.
Yes, I mean, there's another interdict which has been brought by Sustaining the Wild Coast, non-profit company, and various communities situated along the Wild Coast, and also the DSTV communal fishers who have already had their rights to subsistence fishing determined by a high court. So that case has kind of come on the back of ours, and they will similarly seek an interdict. So that matter is set down for the 14th of December.
Are you all muscling together? Are you rallying behind these various other groups and agencies that are putting in their own interdict, or are they working as separate teams?
No, look, well, I mean, I think this is a clear case where as many legal skills as possible are needed, as many legal and oceanic minds and scientists come together to support these cases across the board.
Now, walk us through your arguments in the Makhanda High Court, Rick, and obviously what some of those shortcomings might have been.
Okay, look, we didn't necessarily ask for an immediate interim interdict, so we actually went on a rule nasa basis where we sought just a very short-term interdict, possibly even as short as 7 days, which would have then given us and also our opponents the opportunity to supplement our papers. So we had included an amount of evidence which we considered satisfactory to at least convince the judge to grant a return day, and then at that return day we would have presented further evidence as to the harms and potential harms of seismic surveying in the oceans.
Now, what is that harm? Because according to the judgment that was issued down, you have not been able to show that there will be irreparable harm to the marine environment. Do you now have this evidence?
Well, look, I think even amongst the science community, and I guess that's one of the bases of science, is that it's continually improved. But I mean, what is clear is that the science that was relied on in 2013, when the Environmental Management Program was approved, there's been significant further studies published across the world in that intervening 8-year period, which would indicate that there are harms. I mean, I'd like to say, no disrespect to the magnificent beauties, whales and dolphins, but it's about far more than whales and dolphins. So there's already proven harms to fish larvae, for example, and even to phytoplankton, which is the food source of whales. So, yeah, I'm fairly convinced that the evidence is there. There's many experts, as you can imagine, all around the world that have reached out to us to even volunteer their services pro bono to make sure that the evidence is put before a judge, I guess in a manner that legal people that need to interpret the law can interpret the science in a legalistic manner.
Now, Rick, interpret this for us. So, Integrated Coastal Management Act of 2008 defines the areas in which Shell proposes undertaking these exploration activities as coastal public property. I beg your pardon. Has the public been consulted? Because surely the government is custodian of this area on behalf of the public. So one would imagine that there must be some consultative process in which the public were engaged before authority was granted.
Yes, I mean, you raise a critical piece of law, and that's part of our argument too, that as far back as 2013, when the exploration right was granted, the NEMA Integrated Coastal Management Act wasn't even taken into account. The Environmental Management Program doesn't even list it as a relevant law to take into consideration when granting exploration rights. The only reference to the ICMA in the entire Environmental Management Program that Impact Africa and Shell put together was actually a comment that I put in on behalf of 77 interested and affected parties that I was representing at that time. So, look, there was consultation, at least around the Environmental Management Program. But as to what followed thereafter, there was never any notification that the exploration rights had even been granted. There were no notifications of the applications for renewal. There have been 2 applications in the intervening period. No public consultation in respect of material transfers in the interest to ExxonMobil some years ago, and then the more recent one to Shell. So, yeah, I think in the broader context as well, public participation, and there's sufficient case law on this, even from the Constitutional Court, of course. It's not just a mere notice thing, where notice is one part of it, but you must actually deliberately engage. I mean, Judge Governji captured it quite well in his judgment that a mere formalistic approach doesn't tick the box of consultation by any means.
Rick, allow me to ask you one more question. Our reporters have been across the country following a number of protests that are taking place where individuals that are concerned with the seismic activity are obviously protesting against it. Shell is in the business of making money. These protests are speaking out against Shell, and some of them have stopped sales at Shell service stations in Johannesburg in particular. Do you think that this will be sufficient pressure to urge Shell to reconsider?
I like your optimism. I don't share it. Look, I think there's been a big wave. I mean, I myself am at a similar protest at Cape St. Francis in the Eastern Cape. And there's a lot of people here, a lot of children, a lot of kiddies, a lot of people that care about the ocean. I think that the message is very clear that the ocean is not for sale. And the reality is that it's been carved up into exploration rights from as early as the 1960s. And this is all public information on PASA's website. So I would encourage every member of the public that has an interest in this and the further conduct of these matters to go have a look for yourselves. And you'll very quickly realize that more than 80% of South Africa's exclusive economic zone and territorial waters is already allocated to oil and gas companies. So, yeah, we can only hope that the public momentum continues, but I think South Africans well know now that if we are to get protected and have our rights protected, it's only the courts of law that will do that, and potentially only the Constitutional Court. But we'll get there, one step at a time, one day at a time. It's a new day today, beautiful sunrise, and fantastic African blessing of a day full of rain in the Eastern Cape, much needed. But thank you, Hugo.
Rick Stone, appreciate your time, and I do hope you have time. Rick Stone is the lead lawyer in that case against oil giant Shell, against their seismic activity that is proposed for the Wild Coast.